Hello, one and all. It's been a long time since I've seen you lot. Welcome back to Magi's Mathematical Mayhem, Episode 2. The title for this episode is Mathematics is a Human Right. A little bit of housekeeping before we get into things. Number one, as you can hear, Baby Cat is very active tonight and may have some opinions about some of the things being discussed in this recording. If she interjects, feel free to make of her statements what you will, and of course take everything I say also with a grain of salt. Critical thinking, right? Second part of housekeeping. All of the references that I will be working with tonight are drawn from Universe Sector 0057 Alpha, or what we interdimensionals call the real world in quotation marks. Tonight's format is I'm basically going to briefly summarize an article called The Dangers of Mathematical Illiteracy in the Legal Profession from bclawimpact.org, a blog by law students at Boston College Law School. And after the summary of each couple of paragraphs, I will list a response based on my background as a former math major and math tutor. The sources that I use will be provided as PDF copies, 2 links in the recording description if anyone wants to, well, look at sources and get more information for themselves. Anyway, on with the thing. So, this particular law student had just started a couple of months ago and was a bit concerned about the issues regarding empirical data. For example, in the first couple of paragraphs here, in a case called Jill versus Whitford, a statistical tool that could have helped detect partisan gerrymandering was dismissed by the U.S. Supreme Court. It was being called sociological gobbledygook, and with the court also saying that statistics is a hazardous enterprise. It was feared that the use of statistics would weaken public perception of the courts. My response: judges and juries need to have proper mathematical education so that they can properly evaluate formulae and statistics involved in various cases, even just to strengthen the image of the courts. The more they become out of touch with society's progress in these areas, the more likely it is that people will believe that justice is more impossible to obtain than it already is, simply because math and technology get more involved in cases. Proof from either side in a criminal or civil trial will be dismissed simply because it's too complicated or gobbledygook. And we're right back into the territory of the Shope's monkey trial. For those of you who don't know this historical piece, a teacher was tried for teaching evolution in Tennessee. Clarence Darrow, his defense lawyer, tried to bring scientific evidence in, but it was deemed inadmissible. So then he put the prosecution lawyer, William Jennings Bryan, on the stand to testify as a biblical expert, and in 2 hours showed that creationism is not scientific by making Mr. Bryan admit that his beliefs had little scientific basis. Let's not go down that road again. The next couple of paragraphs talk about another major issue within the legal profession. Briefly summarized, mixing up the philosophical and arithmetic definitions of negative can lead to courts dismissing statistical evidence that shows a reduction in certain types of crime on the grounds that one can't prove a negative. With respect to the negative effect fallacy, as it's called, yes, one can't directly prove a negative. However, if you apply a limit theory from calculus, that basically means numbers trend to a certain point, then as the empirical evidence approaches a certain point, one can argue that prevention of crimes like illegal search and seizure is possible. This also allows for preponderance of the evidence to be properly evaluated for all cases, even those requiring reasonable doubt to establish innocence of an accused. Now, the next couple of paragraphs in this blog article talk about whether or not the mathematics can help provide tools to be able to define concepts that are common in law, such as reasonable, sufficient, or significant. The original author of the blog post wasn't sure, but I disagree. Mathematical terms can be used to define reasonable, sufficient, and significant. First, statistics has a very specific definition of significant, which means that the probability that any experimental or empirical result has less than X probability of happening as a fluke. Remembering the old phrase, extraordinary claims require extraordinary proof, a cutoff value for X, or alpha as the statistical community calls it, can set an appropriate probability of the empirical evidence being a fluke and look for probabilities less than that to establish reasonable and sufficient grounds for any particular trial. Hell, Bayesian analysis could be done to establish the quality of evidence being presented, given prior probabilities, and reasonable and sufficient could be established that way, again, with a certain probability threshold being reached. Now, for the last couple of paragraphs, some academics have been suggesting that statistics and research methodology classes be given to law students to help them through these kind of situations. One prime example of this is the new self-driving cars which are on the market, which law will have to decide how they are programmed, especially so that this way self-driving cars reduce harm while still getting the driver from A to B in numerous kinds of situations. My response is, the problem with self-driving cars is that they need a moral code programmed into them while being attached to a neural network so it can make moral judgments based on variables on the road. There is a paper which describes how to set up science as a moral code, which could aid in such programming, linked in the description, along with the other sources. However, until neural networks and AI become much smaller and more efficient, programming a self-driving car with such a system is going to be very difficult at best. Anyway, that was my response on that. The writer summarizes that basically legal scholars are going to have to catch up with technology, and I'm in complete agreement. So with that in mind, sources will be provided in the description. Feel free to read at your leisure. And as always, thanks for watching. Have a great day, all.